On January 30th, 2026, as the country was still settling into a new political year under President Donald Trump's second term, the United States Justice Department pulled back the curtain on one of the darkest and most closely guarded chapters in recent American history. On that date, officials confirmed that the department had begun releasing what they describe as the remaining files from the Jeffrey Epstein investigation, a trove so vast and so sensitive that it has been fought over for years in courtrooms, in Congress, and in the court of public opinion. Viewers tuning in are watching this unfold in real time, with federal officials acknowledging that more than 3 million pages of records are now being posted online in waves throughout the day under the authority of a new federal law that Congress passed with near-unanimous bipartisan support in late 2025. These are not just routine case files. The Justice Department has disclosed that the release includes more than 2,000 videos and over 180,000 images seized during the years-long investigation into Epstein's alleged sex trafficking operation. Some so explicit that even to click and view them, users must first confirm they are adults and pass through age verification gates. At the center of tonight's breaking coverage is a clash between two powerful forces. On one side stand Epstein's survivors, many of whom have spent years demanding that these documents be unsealed, insisting that the full story of who enabled Epstein, who protected him, and who may have participated in his crimes must finally be put on the record for history. On the other side is a Justice Department that, even as it announces that the last of the files are being released, is under fire for missing court-ordered deadlines, for heavy redactions, and now for a deeply troubling failure to protect some of the very victims it claims to be serving. Deputy Attorney General Todd Blanche, speaking on behalf of the department, has tried to frame this moment as a turning point. He has emphasized that this massive release is the culmination of months of nonstop work inside the department, where hundreds of government lawyers have been pulled off other cases and reassigned to comb through the Epstein materials line by line. He has stated that the review is complete, that the goal has been transparency and closure, and that the public is finally being given access to records that once sat behind layers of secrecy. But as viewers watching these developments unfold can now see, the story is far more complicated and far more politically explosive than a simple narrative of transparency at last. This release is happening under the Trump Justice Department in a climate of intense speculation about what the unsealed materials may reveal about powerful men, famous institutions, and high-level political figures. Among the most closely watched names in these files is President Donald Trump himself. Federal officials and journalists confirmed that the FBI, in August 2025, compiled a list of sexual assault allegations involving the sitting president that were associated in some way with the broader Epstein probe, some claims reaching back many years. Yet those same officials are quick to stress that many of the allegations recorded in these FBI forms, known as 302s, are unverified, second-hand, or even third-hand accounts, entered into the record because the Bureau's procedures require agents to document what witnesses say, then take the time and resources necessary to try to determine whether any of it holds up. At the same time, the newly released documents contain repeated references to former President Bill Clinton and to individuals in his orbit, including a former White House counsel who allegedly went on to represent Epstein and his estate, and is heard referring to him in strikingly favorable terms. All of this is landing in an already charged environment. The law that forced this release, often referred to as the Epstein Files Transparency Measure, did not arise spontaneously. It followed years of relentless advocacy by survivors and their attorneys, by investigative journalists who exposed failures in the original handling of the Epstein case, and by lawmakers from both parties who came to see the files as a test of whether the system protects the powerful at the expense of the vulnerable. By November 17th and 18th of 2025, that pressure had reached a breaking point. In the House of Representatives, the Epstein Records Bill passed by a vote of 427-1, a margin almost unheard of in modern American politics. In the Senate, it cleared without a single objection. Republicans and Democrats, liberals and conservatives, all aligned on a single proposition. The American people deserve to know what was in these files, and Epstein's victims deserve to see the government finally take their claims and their dignity seriously. It is against that backdrop that Deputy Attorney General Blanche took to the podium and tried to strike a somber, almost apologetic tone. He acknowledged openly that victims of Jeffrey Epstein have endured unspeakable pain. He did not attempt to minimize their suffering or suggest that their frustration with the government was misplaced. In fact, Blanche conceded that to the extent there is anger or distrust directed at federal authorities over how this case has been handled, he understands why. He referenced what the public already knows about Epstein: his access to power, his wealth, the long trail of accusations that seem for years to go nowhere, and said he hoped that the work done over the past 2 months by the men and women of the Justice Department would, at least in some measure, help bring a sense of closure. For viewers listening carefully, there was an implicit recognition that no document dump, no matter how comprehensive, can fully repair what was broken when Epstein was allowed, for years, to move in elite circles even as disturbing allegations piled up. Moments later, CNN Justice correspondent Evan Perez joined the broadcast to unpack some of the most sensitive political dimensions of this unfolding story. Perez reported that in 2025, as the Justice Department prepared for the possibility that Congress would force its hand, the FBI assembled a list of all sexual assault allegations that touched on President Trump and had been captured in connection with the Epstein investigation. These were compiled into FBI 302 records, the standard reports agents complete when they interview witnesses. Perez emphasized that the presence of an allegation in such a file does not mean it has been vetted, corroborated, or deemed credible. In fact, he said, the current understanding within the department is that many of these claims could not be verified. Some stem from people recounting what they say they heard from others, or from rumors that circulated among those in Epstein's orbit. Still, their existence in the files ensures that they will be scrutinized, dissected, and debated, not only by investigators and attorneys, but also by the public, the media, and political actors who have been waiting for any new information linking Trump, Epstein, and alleged misconduct. As Perez noted, some of the documents that drew the most attention upon their initial posting, including those that contained especially salacious and uncorroborated claims about the president, were quickly taken down from the Justice Department's website. It is not yet clear why. Officials have, in previous rounds of Epstein-related releases, temporarily removed documents to apply additional redactions or correct technical errors. That could be happening again here, but without a clear explanation, the sudden disappearance of specific files only feeds speculation. While this is happening, viewers are reminded of something else that is already well documented and undisputed. Donald Trump and Jeffrey Epstein were friendly for a number of years. They socialized in the same Palm Beach circles, were photographed together at Mar-a-Lago, and moved in overlapping social and business worlds. Trump has acknowledged the friendship, but insists he knew nothing about Epstein's criminal activity with underage girls, and that once he saw behavior he considered unacceptable, he cut ties, banned Epstein from Mar-a-Lago, and had no further relationship with him long before Epstein's final arrest in 2019. Yet even as the conversation turns to presidents and power brokers, the heart of this story remains with the survivors. The very people who push this process forward are now sounding the alarm about how it is being carried out. In the hours after the new files began to go live, disturbing reports emerged from survivors who said they had found their real names that had been protected in the court filings as Jane Doe, spelled out in black and white in the released materials. These revelations stand in direct contradiction to assurances from the Justice Department that no personally identifiable information about victims would be disclosed. The department had promised rigorous redaction to shield survivors from further harm. Instead, some say they clicked through the site only to discover their own names, details of their abuse, and even copies of documents like driver's licenses that had not been properly obscured. For viewers, the gravity of that failure cannot be overstated. After enduring years of silence, disbelief, and institutional failure, these women are now confronting the reality that the very process meant to bring transparency and accountability has exposed them yet again. To explore these concerns, CNN brought on Eric Fidali, an attorney representing 11 of Epstein's accusers. Fidali did not mince words. When asked whether the 3 million pages, the 2,000 videos, and the 180,000 images released today represent everything the Department of Justice has, he answered flatly. Absolutely not. He pointed to public statements from the department itself that indicate certain categories of material have been withheld or heavily redacted. Among the most troubling justifications cited by the department, in his view, are claims of attorney-client privilege and ongoing investigations. Fidali argued that without an independent overseer, the public and the victims are left simply to trust that the department is accurately applying those legal standards. But attorney-client privilege, he observed, is highly nuanced, especially when applied to prosecutors, who technically do not have clients in the traditional sense. The notion of an ongoing investigation, he added, can be invoked so broadly that almost anything could be withheld if officials chose to use that label. That, he said, is what makes this moment so frustrating and alarming for his clients. Fidali went further, characterizing the release process as a deeply troubling blend of alleged cover-up and incompetence. On one level, he suggested, there appears to be a concerted effort to keep certain information from public view by citing privilege or investigations with no external verification. On another level, the actual handling of redactions has been so sloppy that victims' names and identifying details have slipped through, what he described as a perfect storm of trying to hide what should be public while accidentally exposing what should have been hidden. He cited as an example reports that a driver's license belonging to a survivor was visible in the released files, complete with her name. That, he said, is incomprehensible and emblematic of how poorly this process has been managed, especially given that the department is already a month and a half past the deadline set by law. Despite all the extra time, despite the deployment of hundreds of lawyers, documents are still being produced that are not fully redacted. These failures have fueled calls for judicial oversight. Fidali explained that members of Congress have asked federal judges in New York, who presided over the major Epstein cases, to appoint a special overseer to independently supervise the production of documents and ensure compliance with the law. His team, he said, is in the process of filing amicus briefs and letters supporting that request on behalf of his clients. For many survivors, the appointment of such an overseer would represent a crucial check on the Justice Department's discretion. It would mean that someone outside the executive branch, someone accountable to the courts, would review decisions about what is being withheld, what is being redacted, and how victims' identities are being protected. The question of political influence also hangs over this moment. When asked whether he believes Deputy Attorney General Blanche's assertion that the White House had no influence or control over the review process, Fidali expressed skepticism. He pointed out that on this issue, Congress has been united, the public has been overwhelmingly in favor of full disclosure, and there has been no visible opposition from the broader political system. The one consistent source of resistance, in his view, has been the Trump White House. He noted that the Justice Department did not need a new law to release these files. It could have chosen transparency at any point. The fact that it did not, he argued, suggests the existence of another force resisting disclosure. In his assessment, the logical conclusion is that this administration, more than any other actor, has been the one blocking or slowing the release of the Epstein files, and may still be doing so even as it announces that the process is complete. For viewers, tonight's developments mark both an ending and a beginning. On paper, the Justice Department says the review is done, the mandate of the new transparency law has been met, and the Epstein files that were once locked away are now finally open to scrutiny. In practice, journalists, lawyers, members of Congress, and ordinary citizens are only starting to sift through the mountain of material that has been posted. Questions about presidential conduct, about the behavior of other political figures like Bill Clinton, about the role of lawyers, bankers, and socialites who moved in Epstein's world, and above all about how so much could have been allowed to happen for so long, will not be answered in a single news cycle. They will play out over weeks and months as more information is digested, analyzed, and contested. But for the survivors who forced this moment into existence, the measure of success will not be the number of pages or videos released. It will be whether this long-delayed disclosure leads to real accountability, lasting reform, and a justice system that, in the future, does not need an act of Congress and a nationwide outcry to tell the truth about the powerful and the crimes committed in their shadows.